think an explanation is owed to the public. This was not turning what I ruled would be an open session into an in-camera session. No. The reason for going out is that everybody will recall that earlier I asked on a totally different point or issue. I asked Mr. Premhead to read certain paragraphs for himself, and then I put questions to him. The reason for doing so was to avoid divulging the sort of information that I said, or in my ruling, should not be divulged. So that's why those paragraphs were not read publicly. Now, this time around, I wanted to do the same thing. That is, refer Mr. Premhead to a paragraph for him to read for himself. The reasons were exactly the same. The problem this time around was that I did not find my correct note which directed me to the paragraph, and I was only able to find it once we were outside. So Mr. Premhead, I believe, has now already read the paragraphs. Now, here's my question, Mr. Premhead, and it relates to both paragraphs. Why is it that if Mr. Carrim could do what is stated in those paragraphs, why is it that he cannot likewise do what he has been required to do, which is to furnish the information that has been requested repeatedly?
Paginated page 45. Paragraph 53.1. I can't read it for obvious reasons, but I'll ask that.
Oh, sorry. For the record, let me just mention, because I did refer you to paragraphs by paragraph number.
Yes.
This time around, for the question I've just asked, the relevant paragraphs are paragraph 25 and 66.
Chair, I think it was 69 on page 25, and then, oh, is it not?
Page 49, paragraph 66,
Yes.
and page 25, paragraph 69.
Yes, I did it. Yes.
Yeah.
Paragraph 25.
Thank you. Okay.
So that's the first answer, is the one that I gave, is paginated page 45, paragraph 53.1, which adds some color perhaps as to why something that is described as a simple issue or decision or divulgence is not as simple as it is. I would particularly ask the commissioners to look at the sentence beginning second comma on line 3 of that paragraph. That's the first part of the answer. The second part of the answer is paginated page 48.
Sorry, but what do you make of the word interactions there? Would that be the sort of interaction that the doctor is talking about here?
Yes, that's my submission.
Okay. All right. Please continue.
And on that page, if you look at the sentence beginning third, which is 4 lines from the bottom, that adds further color and context. The second answer I will give is paginated page 48, paragraph 65. It's a long paragraph, but the part of it I would want to emphasize is the last sentence starting at the top of page 49, which is just above the paragraph the chair referred me to, which is 66 on page 49, starting rather, and it's 3 lines. So why I point your attention to those paragraphs is for 2 reasons. The first one is you've heard me already. I'm not going to repeat myself, but Chair views those 2 other individuals who I'm not going to name as having a greater role perhaps in the running of the businesses. I pointed out the fact that according to what the affidavits say, that is perhaps not correct, but obviously Chair will make his own assessment. And then the second reason I'm pointing you to these particular paragraphs is to say that even if it's as simple, in inverted commas, or an instruction to be given by Mr. Carrim to those individuals, those 2 paragraphs need to be borne in mind in respect of the instruction and the ability to give that instruction.
How I read this is this. What comes before 66, which is the paragraph I referred you to, what comes before 66 deals with why Mr. Carrim would ordinarily not be in a position to be of assistance. But what is in 66 qualifies all of that. It even uses by contrast. So it's contrasting what's stated in 66. So you can't read what comes before the contrast in isolation, as it were.
Yes, but with all due respect, I think if you look at 67, for example, the next paragraph down from 66, and if you look from the 4th last line from the bottom, regarding what the doctor says is his clinical opinion, then what Chair says to me is the qualification in 66 in respect of what comes above in respect of 65, which is the paragraph I relied on, is itself further qualified regarding Mr. Carrim and his ability, and what the inherent risk is throughout the proceedings. May I
ask this, and I hope this will be the last question I'm going to ask. Why is it that Mr. Carrim's founding affidavit, which is followed by a supplementary affidavit, does not deal with the... No, I will drop that.
Because it deals with that has to go to who the deponent is.
Yeah,
That's my answer.
I will drop that question.
But can I just say that my third answer to you, Chair, and this speaks to the context of the instructions that I said I would undertake to give. I'm reading from my phone and I'm paraphrasing, so this can be dealt with formally after the fact, if needs to be, but I am told as follows. Contact was made by my attorney with the deponent of the founding affidavit, who contacted the treating doctor whilst he was consulting with Mr. Carrim. The purpose of that was to take an instruction on the issue that Chair and I were debating earlier. And we are advised that Mr. Carrim has suffered another medical incident and that no instructions can be obtained by him in respect of what Chair has put to me. and this is in the context of this facilitative process that we've been talking about. I'm also told that the clinician has expressed his frustration to Mr. Carrim's attorneys because, in his view, his client's position is deteriorating as a result of the pressure being put on him by his attorneys in respect of commission and commission business. And so what that relates to is exactly what I pointed out to you in those paragraphs I flagged. And that's the situation we find ourselves in.
I remember the question I wanted to ask. The mistake I made was to want to relate it to Mr. Carrim's wife, the deponent, to the affidavit. What I meant to do was to say, why is it that Mr. Carrim's doctor does not deal specifically with this issue? You will have noticed that...
About the, sorry, Chair, specifically the issue, the accountant auditor issue.
Yes, why I raise it is because that's quite pertinent, and the doctor has dealt quite extensively with some matters of detail, even dealing with issues relating to his whereabouts. And if I read his reports correctly, I do not recall that he deals with this aspect at all. And to explain why Mr. Carrim cannot furnish the required information. I might be wrong. Maybe it's somewhere there. That is somewhere in the reports.
Well, and I think this is the best answer I can give you. If you look at paragraph 53 on paginated page 44, that will tell you about the doctor's intervention, so to speak, in Mr. Carrim's business affairs, or what he did in respect of Mr. Carrim's business affairs. A similar point is made.
But that's about him not running his businesses, which explains why someone else has been appointed.
Correct.
It doesn't answer the one issue. Such and such information is required by the commission. So 53 does not answer that.
No, correct.
Yes.
But I was...
That's not running his business.
No, correct. The point that I was going to make is 53 and 55 on page 45 give you the context of how the doctor enters the equation, for lack of a better phrase, which is to give the family certain advice regarding what happens to the business. The doctor himself never says that he gets involved in the business per se. He has a facilitative role where it's appropriate to play a facilitative role. And there are instances where sometimes that facilitative role is more restrictive, not less restrictive. And the answer for that is that paragraph I gave you on that same page, paragraph 53.1, page 45. So the reason it's the best answer I can give you is because the doctor himself says that whatever matter has to go to Mr. Carrim through the doctor is not just simply relaying a telephone message or relaying a question, but that the doctor himself has to make a clinical assessment at that moment in time, for example, about whether the question, if put, would cause a deterioration or not, or whether, even if the question is put, the answer given is a good answer or a bad answer for whatever clinical views the doctor themselves may have. So I can't speak to why he did not deal with that specific issue isolated as a line item, but you've also heard me that when instructions, as a real life example of what has happened when instructions were sought, but that adds context as to why he might not have dealt with it. That's as far as I can take it.
Thank you. That's my last question. Thank you, Mr. Premhead. Yes, Ms.
Thank you, Chair. Is it my turn now?
Apologies to Ms. Hassan.
It was
No, no,
1
no.
hour and 51 minutes.
No. It was what, a couple of minutes only. So it was my, it was by 15 minutes. Ms. Hassan?
Chair, I will be extremely reasonable and I won't ask for an equivalent amount of time as Mr.
Which will
Premhead.
end at what, 9 minutes to...
It's 9 minutes to 4 now.
Yeah, so 9 minutes to 5. Please, yes.
So, Chair, can I do this? Can I just address the last topic you were debating with my learned friend and just close that off? Because I was going to deal with it in any event in the course of my address. But since you are on it.
The way the issues, or we'll deal with that at the end. Maybe do that at the end. The issues about possible rulings. The two issues Mr. Premhead raised right at the beginning.
No, I'm talking about what you were just debating now.
No, I'm saying I said I'll raise those issues with you when you begin your argument.
Yes.
Should I perhaps address those right at the end?
Those were the issue of the footage
Yes.
And the redaction of the record.
and the redaction of the record.
Yes. Oh.
Can I just deal with this topic that you were
Okay, all right,
debating,
all
and then
right.
I'll begin with those.
All right.
Turn to those rather. So just on this, because it's fresh in your mind, because you've just been having the debate with my learned friend. The few points I wish to make about it, because I must admit that I find it quite an extraordinary claim that has been continually held since the time the Commission first asked for those documents. Well, first of all, one is not even a document, it's just the name of the auditor. That's all. It's a very simple request. Why I say that I find it extraordinary is because that request was made as far back as when Mr. Carrim appeared in this commission. That was on 9 and 10 March. On 10 March, it was itemized. What the specific, it would form part of a list of requests that we had. We itemized the requests. In fact, I'm sure if we go back to the transcript of the 10th of March, somewhere towards the end of the transcript, it will be there. So this request is months old. That's the first thing I'd like to say. The second thing is that if we look at paragraph 66 on page 23, the paragraph reads the first sentence. In fact, let me just read the paragraph. Before 13 April 2026, before 13 April 2026, my husband was fully involved in his businesses. And then she explains now what that involvement entailed. But there's no explanation to us as the evidence leaders or to the questions that have been posed by the commissioners why these documents and this information could not have been provided between 10 March and 13 April. There's just no answer to that. Instead, what my learned friend does is he goes to the various paragraphs that have been debated just now. For example, on page 74 of the paginated bundle, where the chair, I think it was the chair who directed my learned friend to paragraph 40.1 and the person and the PA and the issue of the FNB accounts. And my learned friend tries to say, well, actually, it was just a rubber stamping exercise because all she did was place an electronic signature. That's not borne out by the text in that paragraph. That paragraph doesn't say that's all she did. It says that's one of the things she did, is that she appended an electronic signature. But that's not all she did. That's not what that paragraph says. What my learned friend is doing is with respect, taking liberties with the construction of these various paragraphs, and he's straining to defend an indefensible proposition that there is nobody in the company or in any of these companies which do business in the amount of hundreds of millions of rand who can say who the auditor is or where to find the financial statements. And I'll just make one last point because I mustn't, for the sake of completeness, on page 25 on the debate in paragraph 71, that his son has stood in for him. What that paragraph says is that he assumed overall responsibility for overseeing the businesses and ensuring that their operations continue in his absence. He is a central point of contact, attends to matters requiring attention, oversees the payment of expenses and the continued performance of existing obligations. And then read that with 67.3, which my learned friend went to explain, well, that the role of the son is that he doesn't make strategic decisions. Well, yes, that's true. 67.3 says he does not make strategic decisions or decisions concerning new business. So we're not making any queries in relation to new business. We're making a query that falls smack bang in the middle of what Mr. Carrim's son is responsible for, as articulated in paragraph 71. So those are our submissions on that particular topic. Now, I don't need to go there later on in my address. So, Chair, on the question of the redactions, we have no objection to that. On the question of the CCTV footage, what I'd like to say is that, and what I would like to make clear at the outset is that the point of the evidence on Mr. Carrim's movements is not put up to try to disprove a psychiatric diagnosis. It's not put up to...
Chair, I must just interject.
I apologize. It slipped out.
This is now the second incident where slippage is occurring. It happened the last time as well. And I would ask through you, Chair, that the evidence leaders please pay extra special careful attention to the choice of words because of the exact reason we asked for an in-camera hearing. This is now the second occasion it's happened.
Chair, may I apologize? It's in the course of speaking off the cuff.
It should not happen. It simply should not. And as Mr. Premier says, this happened at the last hearing. Mr. Shaskalson did exactly the same thing.
I'm aware.
It should not happen.
My profound apologies. It was entirely unintentional.
Chair, may I just say, and I'm sorry to do this whilst my learned friend is now on her feet, but the fact that I've had to object has itself now drawn attention to something potentially. And so my client's rights are now really being prejudiced because, and I make no statement about Ms. Hassan, who is a consummate professional, and I fully accept it might have been an accidental slip. But even the fact that I've had to record the objection now elevates the issue and creates the very damage that we've tried to protect my client from. And I'm in an invidious position where I am where I am. And so I would ask, Chair, not that you can control the media or anybody else, but just to remind people about their responsibilities in what they say publicly regarding the impact that can have on the dignity and privacy rights of someone who's made an express claim for confidentiality to avoid this exact situation. And I'm sorry to interject my learned friend while she's on her feet, but I have to now place this on record as a matter of principle that we're heading into dangerous territory.
Thank you, Mr. Prem. for now, let's leave it at the point that I have made, the admonition that I have made, and let Ms. Hassim continue.
Thank you, Chair. And I do reiterate my apologies. It was entirely unintentional. It's difficult to take out from one's head all of the information we've been looking at and reading and dealing with over the last few days. What I wanted to say was that the point of putting up the evidence on the movements is not to disprove any diagnosis, not to use it to challenge the clinical findings of a treating doctor. But it is important because what it does is it bears directly on Mr. Carrim's demonstrated ability, his day-to-day functioning capacity. That's what the movements go to. And it also goes to something else, which is, and I'll come to it later, that it's about the reliability and completeness of the information that was before the treating doctor at the time when he deposed to the affidavits that we now have in this application. So that's the relevance of the movements.
Are you saying, because the issue, as I understand now, is about flighting or not flighting?
That's right. So,
are you saying you require flighting for purposes of what you've just explained?
No, Chair, it was just a preliminary point to explain why we go here at all, that it's not simply for the purpose of showing that Mr. Carrim was in fact in Durbanville on the 14th of July. It's not merely for that fact. It's more than that. But I can continue to make my submissions to the second point that I'm raising about day-to-day functioning without flighting the footage. And I will make that.
That's exactly how I understand it. I do not see what stands in your way to make those submissions without flighting. I simply do not understand. But as you say, you've just said now, you are able to make those submissions. So
I'm perfectly... Yes. I don't need to rely on the footage in order to make those submissions. And
because there's the admission by Mr. Carrim through the deponent, his wife, that he was indeed in Durbanville and at this particular shopping center, that he went to Woolworths and this other place. I can't pronounce that name starting with a K, with many vowels in it.
Kauai. So I'm going to talk about that evidence, but I don't need to flight the actual CCTV.
Thank you. So that takes care of Mr. Premi's, one of Mr. Premi's 2 points.
I think both, because we also have no objection to the redactions.
All right. Thank you. Thank you. There was, what was the third thing?
Geolocation.
Oh, yeah, there was the issue about the geolocations.
Oh, yes. I think in the context of the sensitivity of what we're dealing with, and perhaps, Chair, I should just refer to the ruling that you made yesterday, because that's the constraints that are governing my ability to make submissions to you candidly. So the ruling, Chair, would you indulge me reading out paragraph 2?
Please.
Because then it might help the public also understand why we're talking in this coded way. So paragraph 2.1 says the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention Mr. Carrim's medical condition, the nature of the treatment he is receiving, the identity and nature of practice of the health professionals attending to Mr. Carrim in respect of the medical condition, and the medical facility where he is admitted. 2.2, publication or dissemination in any format of the information referred to in paragraph 2.1 is prohibited. 2.3, the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention the names and residential and business addresses of Mr. Carrim's family members. That's the relevant part of the ruling. So, Chair, I am not going to flight the geolocation spreadsheets. They are in our papers. Everyone on Mr. Carrim's legal team side has seen it. The commissions have it. I don't think it's necessary to do that. I think if we were to do that, we would run into trouble. It's not possible to redact every single entry, and some entries are relevant to where perhaps Mr. Carrim's family members are. So we won't flight that either. So, Chair, and then consistent with this ruling, what I propose to do is, and I'm going to try to stick to a script a little bit, because when we are in open debate, then mistakes happen. With your approval, I intend to refer to the two doctors as Dr. Initial and Dr. Initial, to distinguish between the two. Would that be acceptable to the chair?
Why not use the first doctor and second doctor?
Okay. Okay.
And you can simply say, for example, first doctor being the one with the substantial reports that we have in front of us. And I'm not even sure who the second doctor is.
Could I say our doctor, our expert, and their doctor?
Good.
Something like that. Okay.
Thank you.
All right. So I'll proceed in that fashion then. I think the next and the point, and it was the first point that was raised, substantive point that was raised by a learned friend, was that somehow we're not really opposing the evidence leaders, the postponement application, but and that we've conceded something. I'm not sure how that arises. The heart of our opposition as the evidence leaders is that the Commission should not grant a postponement without requiring an independent medical examination. That is the heart of the opposition by the evidence leaders to a postponement. And the reason for that is because we've had a history of postponements where the length of time that we are told that Mr. Carrim will be incapacitated has varied and grown each time. So in the beginning, it was a few weeks, then it was 8 to 12 weeks, then it was 6 months in the latest round of affidavits. So it's very important to the evidence leaders that we have a fixed date for the postponement, number one, and number two, that postponement is conditioned on an independent medical examination. I'd remind the commissioners that this is the fifth postponement that Mr. Carrim seeks, and we've set out the history of the delay at paragraphs 7 to 24 of our written submissions. I'm just going to turn to those submissions. I don't need to go through the details. All I'll point out is that what one sees when one looks through the history of that correspondence and the postponements and the delays is that Mr. Carrim's attorneys seem to believe that a postponement is available for the asking. One example of that is at page 67 of the correspondence bundle. If we could just look at page 67 of the correspondence bundle, And if you look at paragraph 9, this is a letter that was dated 13 May 2026 from Mr. Carrim's attorneys. If you look at paragraph 9, it was again in an attempt to get a postponement of the next hearing. And all we are told in paragraph 9 is we confirm that we have now received the further medical report. This report is highly personal. Suffice to state that our client has been laid off for at least 8 to 12 weeks, and that was all. No medical certificate or report or note or anything accompanied this. It required requests from the attorneys for the commission to obtain the necessary medical report to underpin the postponement request that was made. So that's the history that we're dealing with here, which is why the evidence leaders feel so strongly that getting finality and a specific date is so critical. We then come to the latest. I'd rather go to the most recent history on the postponements. The last postponement was to 15 July. Up until that point, all of the postponements were granted, were permitted on the understanding by the commission and the evidence leaders that Mr. Carrim was hospitalized and that his movement was restricted. That's what we were led to believe. It was only when there were the two whistleblower reports on the 14th of July that the issue of Mr. Carrim's movements were put into question. The evidence leaders then obtained the CCTV footage to corroborate what we'd been told by the evidence, by the whistleblowers. Mr. Carrim was then afforded the opportunity to bring a substantive application for the postponement. And in that application, an opportunity was provided to address the latest information regarding Mr. Carrim's movements around the Cape. And this is addressed in two affidavits. The one, as we've already been talking about, is by his second wife, and the second affidavit is by his doctor. What we were told in those affidavits is important. Their accounts, and I'm not going to go into the detail, it's summarized at paragraphs 39 to 44 of Ms. Berger's answering affidavit. What we saw there was a particular picture that was painted by the two deponents, and particularly by Mr. Carrim's doctor. That picture was one of restrictions on Mr. Carrim's movements and interactions. We were informed that any leave from the hospital would be authorized for specific purposes, that there were passes that were subject to strict conditions, including searches, etc., including on the return of the 14 July excursion, which was said to have been a 4-hour chaperoned excursion that took place between 1:30 in the afternoon and 5 p.m. in the afternoon. That was the account that was provided by their doctor. It was supported by Mr. Carrim's wife. Now, it's important, commissioners, to go to those affidavits. So let's look first at what Mr. Carrim's wife says, and that's at paragraph 60 of the founding affidavit. if I could ask the commissioners to read paragraph 60 and its subparagraphs, where the 14 July incident is explained. I'd like to place emphasis on 60.2, where it says we departed the facility at 1:30. Then 60.3 and the description of the Kauai engagement. 60.4 and 60.6. Specifically where it says we returned to the facility by approximately 5. And then there was a consultation, but they both, I've emphasized the word we in 60.6, attended. In paragraph 73 of the same affidavit, the deponent summarizes world travel since 13 April 2026. And I draw your attention to paragraph 74, where the deponent says, my husband undertook no other travel during this period and did not travel to Mahikeng or any other location in the Northwest. There's a second affidavit, which I'm going to come to, in which this is a different picture is painted. And what the deponent says later is that that trip to the Northwest took place during the week when Mr. Carrim is with his first wife. And so, says the deponent, she did not know about the trip, and that's why she didn't say anything about it. What my submission on that is that that's implausible when we have regard to her own evidence that she communicates regularly with the first wife, and you'll see that at paragraph 15 of this affidavit, of the founding affidavit.
But what about the fact that she says this was the first wife's week, and that she might have missed this visit to Mahikeng or Mahikeng because of that fact?
Yes. I'm saying it's not plausible because they communicate regularly. She explains in paragraph 15 that they communicate, she and the first wife, including about...
Does that mean every and anything of necessity?
No, Chair. So let me then go to paragraph 15. It's because what they communicate about is Mr. Carrim's well-being.
Yes.
And his health.
Yes.
And updates on...
But as I understand it, it was Mr. Carrim who wanted to go there to see.
Yes.
Was it his daughter? I think to see.
Yes. I have no objection.
His daughter.
Yes.
Now, so it wasn't as if I'll be with our husband in Mahikeng, but I'm concerned about his health, because the travel might do this and that to him, in which event the first wife might have had to tell the second wife. Now, this is just a visit to the daughter, which was quite important to Mr. Carrim, because as I understood it, he had not seen her for...
Chair, we don't even need to get into that. We don't take issue with his wanting to visit.
But my point is, with nothing that has been suggested about his health and him going there, I do not see why it would have been necessary for the first wife to tell the second wife about the Mahikeng
For this
visit.
reason. For this reason, Chair, because there was a medical incident.
Sorry.
There was a medical incident.
By the way, which resulted in his,
In the second wife, accompanying
in
Mr.
his
Carrim.
return. In his
Correct.
return. Okay.
Correct.
No, I get it. I'd forgotten about the sudden need for him to return. Yeah.
That's right. And it was the deponent who took Mr. Carrim to the doctor and accompanied him and was with him during the consultation. And so that's why I say.
So your point is it's unlikely that the second wife would have forgotten about this incident.
It was specific.
Yes.
I'll tell you why.
Yes.
Because it wasn't a broad question, tell us about the movements. It was a specific question was asked about movements to the northwest, because that was something that became contentious.
No, I get the point.
Then we have the doctor's version on the 14th July in his first affidavit. And we'll find that at paragraph 45, and I think it's page 43. 43, thank you. So in paragraph 45 is where the description of the 14th July incident is. And what's important here is the confirmation that it was 4 hours, that it was for the purpose of purchasing toiletries, over-the-counter flu medication. In 46, the doctor says, in terms, the facility's records reflect that he departed at approximately 1:30 and returned at approximately 5. He goes on to say he doesn't know anything further about the precise movements during the 4-hour period for which it was authorized. And then says, but in any event, these kind of excursions are not unusual. I'd also like to take the Commission to paragraph 39 of the affidavit of the doctor, because, and that's at page 41. Here too, the doctor says, in terms, I deal next with the facility's leave regime, because I understand that an impression may exist that the facility is a place a patient may enter and leave at will. That impression would be false. And then he explains there's only 1 or 2 ways that a person could leave on the pass of the treating doctor. Or the only other way is if the person discharges himself. What happened next was that the evidence leaders obtained geolocation data. That's the data of Mr. Carrim's cell phone that tracks the movements of the phone. We know from the first, from the first deponent that Mr. Carrim keeps his phone with him. We presented that information to Mr. Carrim's legal representatives on the 17th of July. That then prompted 2 further affidavits. So if I can just go to the first, it's the supporting founding affidavit. Sorry, it's not supporting, it's a supplementary founding. What we see now, what page is it on? It's page 58.
That's where it starts. You want to take us to which?
To the paragraph. I'll do that, Chair.
Oh.
Just trying to find my own reference. Right, I've got it. It starts at paragraph 27. Page 67. And that's where the account is amended. It's confirmed in paragraph 27 that Mr. Carrim was at a shopping centre, that he was at Woolworths, that he was at, she says he then purchased a meal from Kwai, finished his meal at Kwai, and thereafter obtained flu medication. He was supervised throughout by his security detail.
And an important contrast here is that he did not buy a takeaway and go and eat in his car. He actually sat down, had a meal in Kwai, or whatever it's called.
Yes. Yes, at Kwai,
The owners will not be happy with me.
I think they'll be very happy with the free advertisement that they're getting. But so, Chair, the discrepancies are, that's the one. The second is that if you look at page 68, paragraph 28.3, I'm not going to, I can't read it out.
But is the second point you want to make the fact that this pass was not was it 4 hours? The shorter period mentioned, it was not for that, but
Much longer period of time.
Basically, I may be exaggerating if I say close to the entire day.
It was
8 hours or up?
It was almost 12 hours.
12. Yes.
So, as confirmed by this deponent, who says when he arrived at where she was in the morning.
I'm doing that. That is going straight to the number of hours to avoid reading. But
Okay.
I'm not even sure that that's what you wanted to read.
No, that's the second point, which is that the discrepancy in the time.
The hours were much longer.
Yes. So it's two. It's the time of departure and then the time of return, which was about.
And the fact that they did not depart together, which is what was in the first update.
The first one was the we that I'd emphasized. They did not depart together. And the second thing is that they did not consult together either with the doctor upon return. And then the final thing is that consultation took place much later at night than just after 5 o'clock. The deponent also corrects the facts on the travel on the 9th and 10th June to the northwest. And what, yes, those really are the main things that I wanted to make clear from the first deponent's affidavit. The final thing I'll say is that she does also confirm, and that's at paragraph 20 of her affidavit, and this is important given the replying affidavit that came later last night. Paragraph 20, yes, page 65, where the deponent confirms in the middle of the paragraph, I am unable to identify every such occasion, and that is travel and leave excursions from the facility. Subject to this qualification, she says, I accept that the geolocation data generally reflects my husband's movements. I do not dispute the accuracy of the data or seek to explain it away. We've explained in the answering affidavit the analysis of the maps and the geolocation data and what they show. And what they show is that almost every single day, Mr. Carrim leaves the facility. And that on most days, he's out of the facility for at least 8 hours, sometimes longer. So which is what my learned friend was objecting to, the inverse inpatient reference that was made in the answering affidavit, was that he spends more time outside of the facility than he does inside the facility, is really the point of that. So what we get now is a materially different picture from what we first had. And when I say what we first had, I'm saying let's go back. I'm not going to do it now, but if you go way back into history from April, the picture keeps fluctuating. And it fluctuates recently when Mr. Carrim's, when the deponents are provided with objective information from the commission that changes the version that they initially gave. So that information is not information that is in our knowledge. That's within their knowledge.
Please continue.
So what the crux of the point here is, Chair, is that these shifting accounts in the affidavit are important because they show that each time that the deponents are presented with, confronted with objective evidence concerning Mr. Carrim's movements, the explanation changes. Second, and this is important because of the ruling that we seek from the Commission, it underscores why an independent medical opinion is now imperative. And without impugning their doctor's integrity or professionalism, it's apparent that he has not been placed in full possession of the facts concerning Mr. Carrim's comings and goings from the facility. So his own medical assessment and the report that was furnished to the Commission appears to have been based on a flawed factual foundation. So that's another reason we say that the independent medical opinion is required.
The doctor, you've referred us to 4841, where the doctor states that a patient may only leave and underline only in one of two ways, which is a pass by the doctor. And also if a patient wants to discharge themselves. But in the later, should I call it what, a supplementary affidavit?
Yes.
In that one, the doctor now makes a suggestion that other people may, I hope I understood it correctly, other people may, I don't know whether actually issue passes or allow a patient to go out. But other people now are involved, whereas in 40 he said only only one of two ways, a pass by the doctor or...
So now what the doctor says, and it's at paragraph 16 specifically, is that if he's not available, then the nurses will authorize.
That's the point I'm making. Thank you. Yes.
So which is a very fundamental change from the first affidavit. You don't need to have been presented with this data that we provided him with of the geolocation of the phone and the movements that we obtained independently in order to make an accurate statement from the get-go about how movements take place in the facility.
And it is quite telling that you have these movements in the allegations on Mr. Carrim's side, not by one person only. The second wife also moves or changes her allegations once confronted by facts that contradict what she says. And unfortunately, this is happening with the doctor as well. A patient may lawfully leave the facility in only one of two ways. But later, once we have the geolocation and the times when Mr. Carrim would be out of the facility, and suggestions of much, much longer times than what we were made to or given to understand, the doctor as well, just like the first wife, moves and changes and now tells us about the possibility of nurses also issuing passes.
So we didn't ask for this specific question of passes to be addressed in the founding affidavit. That was done of the doctor's own volition. So if the doctor is providing an account of how the system works, why was that not part of the account in the first place? Why did it come up only when presented with different evidence? The second thing is that, that's why I read it out earlier and said, he said so in terms that the facility records will show entry and exit. That changes in the second affidavit. And you'll find that at paragraph 18 of the supplementary affidavit.
That's at page?
Page 84, I'm told. So just paragraph 16 on that page is the nurses. And then paragraph 18 is where the doctor explains that, in fact, what he said wasn't correct because the facility protocol is not followed. That, in fact, the practice of keeping records is that it's just not honored. There aren't any records. The doctor also tells us that he himself doesn't keep records. He doesn't keep his own notes of when he issues or authorizes pass-outs. But he only tells us that in the second affidavit. Sorry, bear with me, Chair, please. I'm trying not to make a mistake again, so I'm going a little more slowly. So the most charitable interpretation of the doctor, he is relying on what Mr. Carrim tells him about his movements. He now knows that he's not being told the truth about the movements. But all those facts were the facts that he based his information on when he gave us these reports. Those reports do not hold true anymore. So my learned friends...
although that charitable interpretation would not apply to the categorical statement that doctor makes, which is people go out only, and he specifies the circumstances under. Yes. So your charitable interpretation cannot apply.
Maybe I'm being too charitable. But the point...
I'm not suggesting you should not be, but I'm just saying it cannot apply to that categorical statement.
No, it can't. Nor to the... I'll leave it there. I agree with the chair on that. My submissions are more to what it means then for the opinion that he expresses, in which he says to the Commission, this is the difficulty and again, what I wished to say at the outset was that the point of it is not to challenge the diagnosis. It's to say, what we're concerned about is functionality. What is Mr. Carrim's ability to engage with questions and information and evidence that may need to be provided to the Commission? That's what we're concerned about. We're not concerned with dislodging anything else, although it may become necessary, and I'm not going to preempt the independent medical assessment that will come. That will give us a better picture, of course. So we can't rely on that. So to say that this report by the doctor is definitive falls on that basis. But the argument that the doctor's report is definitive is also extraordinary for another reason, because it itself is a breach of the professional guidelines that are referred to by our doctor in his affidavit.
I assume you will obviously address the issue raised by Mr. Premhid that applies in the context of forensic what? Yeah, which Mr. Premhid submits. That's not the instance here.
In fact, it's exact opposite. It is exactly the circumstance here. I'm coming to that doctor's report, but it's precisely those guidelines were prepared for precisely the scenario that we're facing today. So I'll come to that. For now, what I wish to say,
I must say, I didn't quite understand why this is not forensic, which is why I put the question to Mr. Premhid, but we'll hear you when you get there.
Thanks, Chair. What my learned friend argues is we must accept the opinion of their doctor. That opinion, as we will see when we get to our experts' report, is provided in breach of those guidelines, those professional guidelines, which say that a treating doctor should not be the person to provide an independent assessment, and of this is the critical thing, of the individual's, the patient's capacity, which the commission is expected to consider, right? The objective determination of the capacity. So we're not talking about diagnosis, but it's about objective assessment of that person's capacity to participate in these proceedings. The guidelines say that it should not be provided by the treating doctor because the treating doctor is inherently subjective and an advocate for the patient. And I'll come to it because he says more things, and I'd rather refer directly to what our expert says. But so that's the thing. This is the first thing, right? But we must accept it, says my learned friend. And then what they say is, and with the support of their doctor, they say that then the witness must be insulated from any examination by an independent specialist. And no one is able to then assess whether that conflicted, what we say is a conflicted determination of capacity by the treating doctor is in fact reliable. Because we've gone through the passages, I'm not going to go back there, the paragraph 73 and 73 of their doctor's affidavit saying that there should not be an independent examination. I don't know yet where we stand on. I know there was a discussion about interposition of another physician, etc. That's not what we are proposing in any event. We're proposing something that is entirely squarely within the professional guidelines. So they say, and they've been saying to us, and Chair, let me just say in response to the question you posed to my learned friend about, sorry,
I wanted to, don't forget the point you wanted to address now. But I wanted to say, is it not semantics to say the IM, is it E?
Yes.
That the IME issue differs from interposing a different doctor? I don't quite see the difference you appear to be seeking to draw, because you would still be bringing in a doctor that's not the treating doctor.
That's
so,
right.
So why you would say that's not interposing another doctor? I don't quite, it's not a serious issue, really. It's
maybe not, but it's important because we want to address the concerns that have been raised.
Okay, all right.
And it has been addressed by our expert, who explains that doctor doesn't take over the treatment of the individual.
The suggestion about interposing is not about this doctor that's being interposed, taking over. It's not about that. It's just for purposes of also doing an assessment.
Yes.
with a view to either confirming or not confirming what the treating doctor has said. So I'm not quite sure that I get. I still do not get the difference you're saying.
Okay, that was my understanding of the difference. But if the interposition goes to what the chair is now saying to me, which would include that, well, then
that's all I meant when I used the word interpose. That's all I meant.
Well, what the guidelines say is that it's not only permissible, it is required that there is an interposition then, in the sense that there's an independent assessment that's testing for a particular outcome, and that's why it's forensic. So
back to your point then, the point you wanted to make. I hope you have not forgotten it.
Well, Chair. Oh, yes, Chair. You posed a question to my learned friend about the lack of a response to the evidence leader's request for an independent examination, and we've set it out in the answering affidavit. There was a correspondence from I think May, if not earlier, in which that was requested.
And don't forget that correspondence was preceded by an undertaking by Mr. Carrim sitting in that witness box. So there's that, and then the correspondence.
And then the correspondence, which went unanswered on that point. We did get answers to other parts of our correspondence, but not to this. It's in our answering affidavit. This history is set out until we pressed for an answer on whether they would agree to an independent medical examination. It culminated in the hearing that took place, I think, on the 25th of June, which was the debate that you were having with Mr. Premid about what exactly was said in that hearing. And I think on that score, I'd rather just go back to the transcript and have a look at it. Our understanding was that there was an objection to an independent medical assessment. And it was quite plain in our understanding, but we can go back to the transcript and have a look at that.
May I request both counsel to furnish us, say not later than the end of day tomorrow, with the relevant part of the transcript?
Certainly, Chair.
Thank you.
So what we're told is, accept our guy, accept what his say so. No, you can't have an independent assessment. And then it gets even more absurd, because the next claim is that no one is able to assess, the treating doctor's determination is unanswered. As we heard, well, it's unanswered, it's unchallenged, and so it must be accepted. So it's a circular reasoning in which...
It's exactly for that reason that I said it cannot lie in Mr. Carrim's mouth to say this is unanswered.
Yes.
Not in the face of what I understand to have gone on, but as I said, I accept that my recollection may be inaccurate.
Well, let me say this. I've not heard, and we know because apparently there was a need for an instruction, so there was never a response to that at least from my learned friend's perspective, there was never a positive response to this, which is yes or no. So why not? That's the question. After so many requests, the stonewalling is no independent medical assessment, and then it's triumphantly, but you see, our doctor's unchallenged, and therefore you have to, and you, the commission, must be now bound by that doctor's assessment. So I think what I should now do, and I would say this, that if their doctor had given a response to our doctor's affidavit, we might have also, perhaps there would have been a shortcut through this. But there is no response. Our expert is unchallenged, in fact. And I'd like to go to our expert's report. What page is it on? page 125 is where the report
Please be
itself.
careful what you read.
So I'm going to go very slowly. And I think what I will do is just refer the commissioners and my learned friend to paragraphs of the report and try to deal with it in that way. But what I want to begin with saying is that this expert has attached his CV. He is the former chair of the professional association that regulates the very field in which their doctor practices. He's extremely experienced, and he is the co-author of the guidelines that he refers to in this report. I'd like to go to page 126, paragraph 5.
Maybe before you do that, if you could just refer to, without necessarily reading it, paragraph 3, because it sets out the purpose of this report. And I think it's important on the back of Mr. Premet saying that this expert has not countered.
Well, yes, no. So this expert was not asked to do an assessment on paper of Mr. Carrim, nor could he have been able to do so because all that he was provided with was their doctor's affidavit. And their doctor, which is something that I should actually point out because it does go to the reliability of that report, doesn't set out the details of things like the treatment protocol, etc. And I don't want to say too much more about that, but there isn't that kind of detail in any event. So it wouldn't have even been possible for our expert to give a meaningful opinion based on that affidavit, which wasn't setting out the full details of the condition. So what he was asked to do instead was to comment on whether the objection, on whether it is clinically appropriate not to have an independent medical examination. That's what he was asked to comment on, and specifically to comment on the objections that were made by their doctor about the interposition or whatever the interposition is defined as. So there was no request for it, Commissioner Baloy. And he would not have been able to do it even if he was requested because of the lack of information. And so what he does at paragraph 5 is consider the affidavit and the objections. And in paragraph 7, you'll see that he respectfully disagrees.
I noticed that your time is up.
My goodness. Chair, I now have to claim equality of arms.
Sorry, by how much did you overrun, Mr. Premier?
51 minutes.
No. I'm not talking. I'm not talking. I remember right at the end, after Mr. Premier had said he was done. I'm referring to that stage, not when we then engaged him after he had said he was done. So the overrun relates to before that lengthy.
Yes, it was 3 minutes or something like that. The additional 50 minutes comes from the panel's engagement with me.
I'm not even counting.
Agreed. So equality of arms is 3 minutes, then not 51.
Miss, how much longer do you want to be? Considering fairness to Mr. Premier, I may have to increase the 15-minute reply time for reply.
A very charitable approach, Chair.
But how much?
I'm indebted.
How much do you?
What I'll try to do is spend less time on the legal principles they set out very clearly, I think.
Take that as read. Take those as read.
So
yeah.
may I have 10 minutes, Chair?
All right, 10 minutes then.
And if I can do it in less time, I will. And one way to do it is to refer the commissioners to the paragraphs, the relevant paragraphs of our experts' affidavit. The statement, it speaks for itself.
Yeah.
The disagreement is in two respects. One is that it disagrees that an independent opinion should not be obtained. And secondly, disagrees that if there were to be an interposition, that there would be therapeutic harm. In fact, he says not to do so, to require the treating doctor to provide their opinion threatens that therapeutic relationship between the doctor and his patient. So I'm just going to say paragraph 10.
At page 127.
Page 127, if the commissioners could just read paragraph 10. I can't deal with it reliably. It would be too risky. But it explains why the independent medical examination has become necessary part of the guidelines, because you need an objective view in the context of.
Okay, you've made the point that it deals with why. We'll just focus our minds on that.
Yes.
You don't need to go through it.
And specifically, just one sentence. These challenges, I'm not going to say what the why are the challenges, but these challenges, if you read in the middle of the paragraph, may hamper the goal of insurers and the courts making sound decisions.
All right.
And then I recommend paragraph 11 at page 128.
Okay, we see that.
And paragraph 14. And then finally, paragraph 19, the conclusion.
Got that.
Then, Chair, what I would also commend to the Commission is the actual publication, which is attached to the report. I'm not going to go there. It's a minefield. There are just bombs all over it, and I don't want to make another mistake, but it's an important report. What I want to say about that report, it's published in a journal of the field, is that it's authored by several highly regarded experts in the field, and it's
I saw reference to it saying international. Am I mistaken? Or am I thinking about anything? I did not see peer-reviewed.
I believe it is a peer-reviewed journal,
Okay.
but I could be. I'll stand to be corrected, and I can double-check whether it is. In fact, it is the journal of the profession. Mm-hmm. It's accredited. I saw that. Mm-hmm. I can't remember if it said peer-reviewed.
In our field, in the legal field, it would never be accredited if it is not peer-reviewed.
Indeed,
Yeah.
indeed so. So, and the one other thing you might have seen is the reference, because part of the literature, this is not a purely South African approach, these guidelines. So this report, these guidelines that are published in the journal also rely on medical literature from other parts of the world. And we referred to one. In fact, we pulled out an abstract of that article for the assistance of the Commission to show that this is not something that is unique to, it's not something that comes out of Mr. Expert's head. I'm stopping on that now. Yes. All that remains then for me, all that remains then, this is the most harrowing submission that I've ever had to make. given the constraints of the ruling. And so I'm going to now draw to a close very quickly, because all that remains for me to say is that we've set out the authorities. The closest analog is the Kwelane judgment by the Constitutional Court. It's in our heads of argument. That judgment also cites very established principles on postponement, which requirements of postponement applications, which I've no doubt the commissioners can recite in their sleep. But importantly, what it says is that if there's a request for a second opinion and an independent medical opinion, that should be permitted. And the foreign authorities support the same, and then of course Michael versus Linksfield and so on, that a commission and a tribunal and a court are not bound by an expert opinion. The foreign authorities are useful because they are in a similar field as to the condition with which we are dealing with here, and it explains what the standard is for sufficiency of evidence, and importantly, independent expert evidence on the issue. And so I commend to the Commission those judgments. And
I wanted to clarify your expert's report, because you refer to it in the evidence leader's affidavit. You say there's no reply to what you refer to.
There's no reply to our expert.
Yes.
That's correct. Other than what we've heard from Mr. Premid, their doctor, their expert, hasn't challenged the affidavit. So, Chair, we request that a postponement on the Never Never must be rejected. We request that the 14th of August be fixed as a date for Mr. Carrim to appear, and that in the intervening period, that there is an appointment of an independent medical examiner who will provide a report, and that might affect then the date of the 14th of August, but at least it will be on the basis of an independent expert. Thank you, Chair.
Thank you, Ms. Sim. Can we take a short adjournment? I won't indicate a time. We'll indicate when we are ready. Let's adjourn.